Hi, Darin Mangum here, securities lawyer, Mangum and Associates. I thought I'd jump on YouTube to talk about a recent court case that's settled, or not settled, but that was decided. It was the Elon Musk Twitter lawsuit. It was a Tesla shareholder lawsuit where a lot of shareholders had sued Elon over a tweet or a series of tweets that he sent out. Seems like Elon, he loved to tweet so much he bought the company, right? So anyway, he had tweeted out that he was going to possibly get funding for Tesla to do a bunch of things, and he had tweeted that out, which later turned out not to be the case. He obviously thought he had gotten funding, but turns out that deal didn't materialize. But a lot of investors decided, hey, well, I'm going to trade and invest based upon that tweet and information. So he said that that was the allegation, right? So the plaintiffs, the shareholders, decided, hey, we traded based on that information that we saw on Twitter, and we lost a bunch of money, right? It turns out that Elon was cleared of any liability, and he is not responsible for any of their losses. Which I think it very much could have gone the other way. It could have gone the way that they could have found him responsible, right? And so why I think that's important, I thought I would just make a case of illustration around, be careful about what you do put out into especially if you're using social media. A lot of our clients, they'll raise capital, say under Regulation D, Rule 506C, which allows for public solicitation, which allows for advertising. Or also regulation crowdfunding is another one where you can advertise and let people know you're raising capital. And even in a private context, let's say you're publishing information regarding a specific project, it may not be directly related to an offer of securities. But at the same time, investors, they see that information, they're going to possibly rely upon it, right? And so it's important to, number one, make sure that any sort of public information that you put out there, that number one, make sure it's actually accurate and true before you publish it, right? And if it may be misleading in any way, don't publish it, right? Don't put it out there. Because again, even though you may have sufficient disclosures on your website, even though you may have disclosures on your pitch deck, even though you may have obviously referencing back to the PPM, which basically says, hey, don't rely upon any other information besides this PPM. I mean, the PPM or the private placement memorandum or the offering prospectus or the offering statement, if you're doing regulation crowdfunding, that is the selling document. It basically says, hey, you're not relying upon anything somebody said or any sort of email out there that may be contrary to this information, right? That's really what the PPM says, right? Now that being said, it oftentimes email or again tweets, things of that nature, they tend to get people in trouble because it's easy for an email or even a text message to be maybe misconstrued by an investor, and it's easy to put out some maybe some contrary information or that may change the deal a little bit, and then as easily as clicking yes or no or whatever, you can potentially modify the deal based upon that tweet. At least it's something that they could. It doesn't mean that they'll be ultimately successful, but it's something that they could certainly use against you to try to show, hey, you modified the deal terms, or I relied upon this other information that you came out with later, not just what was disclosed in the PPM, right? So it's another rock that they could pick up and throw at you. So I would just say, be very mindful of what you text. You may not be as lucky as Elon if you had the same situation. So just be very mindful of what you put out there. And of course, if you're in question as to whether you should publish it or not, especially if it's an email campaign, definitely I would say run it by your securities attorney. Obviously, we're available to review any sort of marketing content like that that you have, but it doesn't have to be us, but yeah, definitely run it by your compliance officer, run it by your securities counsel before you put it out there, because you definitely don't want to be in that situation where you go into trial and you got all this stuff, and even if it wasn't that, it'd be maybe an SEC investigation based on a bunch of tweets or emails that you sent out there. So anyway, just be careful out there. It's a dangerous world. Again, we're here for you, Mangum and Associates. If we can help you with anything like this, feel free to reach out. Hopefully this content is helpful. If you find it helpful, please feel free to like and subscribe to our channel, and we look forward to seeing you on the next video. Thank you.